Hey, Cliff, take it away.
Hi, so I'm Cliff Scott Rudnick. I've been a longtime member of Decalogue. I'm mostly retired, which is like in The Princess Bride. Um, I'm not altogether dead. I'm just mostly retired. And uh, I'm still doing CLEs and traveling a lot. In fact, I see Naomi is on this call. So Naomi and her husband and Nancy and I are off to Buenos Aires in 3 weeks. So we're going to have a good time. But the seminar today is about artificial intelligence. And if you think, oh, I'm not using artificial intelligence, or I'm not going to use artificial intelligence, well, you all are, and you've been using it for years. It's just become a lot more sophisticated in the last 4 or 5 years, in that what's happened is it's kind of taken on a life of its own. And we're going to play with it a little bit today. But you've all been using it. It's all the search engines that you've ever used. When Ted and I began to be lawyers, I started I went to law school in 1975. At the time, Nancy and I both worked for the Department of Public Aid. And I then worked as a union organizer for AFSCME, originally for an independent union. And Nancy, who never took a math course when we were in school and very little science, went and learned how to be a computer programmer. And I went to law school after I was union organizing. And we were very early in getting a PC. But in those days, the PCs were just coming in, and there were no real search engines on them. Google didn't yet exist. We had an old computer that had a green screen, a black screen with green letters on it, and it was in DOS. And I learned to play on that. At the same time, discs started to come in, and Westlaw and Lexis shifted from having books to having discs. And at the time, artificial intelligence was kind of just a concept and a dream. The first time a lot of us ever encountered artificial intelligence, of course, was when you went to see the first movies that involved HAL 2001, when it involved HAL, the talking computer that tried to kill the pilot of the spaceship by locking him out, and he finally turned it off. But there's always been this fear that artificial intelligence and robots would take over the world. Of course, the history of robots is fairly interesting. It was invented by a Czech author by the name of Karel Čapek. And if you've never read his stuff, it's still quite riveting. He wrote a book called RUR, and he invented the word robot. And until then, there just weren't any. Now, when the search engines first started on Westlaw and Lexis, those of us of a certain age remember there were two ways to do a search when you wanted to do research instead of having to go to the books and shepherdizing them. And it became kind of the de rigueur that you had to figure it out. And what you had to do was, I don't know if anybody on the call remembers, and you can put it in a comment if you do, there was something called Boolean search. And you had to do it by saying, if you were looking for some quote of a case and you wanted to check it out, you'd have to put like the word, let's say the word was trespass. And you were trying to see if trespass and landlords had anything to do with each other. So you'd put in the word trespass and landlord within 5 words. It was a whole, almost like doing computer programming. In fact, people thought they were computer programming when they used Boolean language. So then what happened is somebody really smart and good at marketing decided that that was just too much trouble. And they made a natural language search. And it was the beginning of serious AI for people. And what you could do is you would put in this natural language that would take a little longer and go a little slower. But that's how you did your research on Westlaw and Lexis. And that plain language research allowed Google and the other search engines to kind of develop, but they couldn't break through in terms of making it simple for everyone. And then somebody really smart, and I don't know the name of that person, somebody really smart and with some other programmers decided that the problem was that they didn't have a big enough database. And so what they did is they developed a supercomputer and they used it to put in everything they could find. Now, they found a lot of stuff that they weren't entitled to use, and everybody got mad who had proprietary interests in these articles. And it helped destroy newspapers and it helped destroy some other things, but they developed this huge, huge, huge database. And one of the first people that companies that did it was ChatGPT, but a lot of other people since have emulated that, but they put in everything they could find. And so when you go to most of the AI engines, it quickly goes through almost anything they could find that had ever been written, whether it violated a copyright or not, or a trademark or anybody's proprietary interest. And that's how this stuff works, is it so quick and it checks everything and anything that could go. And that's what the search does. And then somebody equally clever decided that this was so unfriendly and so fear creating in people that they tried to put a happy face on these searches. And that's where we are today. So that's what happened, you know, in terms of legal research, in terms of everything else. It's just incredible what's developed. And in a little while, what we'll do is we're going to go through some examples and watch what happens. So one of the things that has been a side consequence of this has been some people have what I would call a Luddite reaction. Now, I don't know how many people on the call know what Luddite means. Does anybody? You can put it in the chat and Aviva can see if anybody gets it right. Unless somebody wants to volunteer and explain what Luddite is.
Can I give you a story to illustrate?
Sure, sure.
Okay, so my path in legal practice was in-house. And when I started work at Kraft in 1976, because I was the youngest guy in the department, I was given the assignments that nobody else wanted. So I was assigned to be the guy who would interface with the systems department, which meant at that time mainframes. And over the years, we evolved. We got our first PC LAN, and I remember going into the general counsel's office, who spent an inordinate amount of time making sure that his furniture for his PC would match the elaborate walnut in his office, because he was in executive row. And then finally it came in, we put in his PC, it was beautiful, and he admitted to me, he says, well, I want to make sure that the CEO sees that I've got this, but don't ever ask me to turn it on.
You know, it's not
far from Luddite.
Yeah, and you know, part of what happened is that I worked at banks. Yes, that is exactly right. But Oren, what they also did was, it happened in Britain. And what they did is they attacked the machines in the factories and smashed them all. And that was their way of keeping from being enslaved by the machines. And so Luddites are destructive and holding back any kind of progress. When I first worked at the banks, well, when Nancy first learned to program, it was at American Hospital Supply, and if they eventually, ended up with AbbVie eventually after everybody else merged and consolidated. But in those days, they batched everything, and everybody did it on computer cards. And the feeling was that you had to be an expert in order to program, and especially at the banks, they were so worried that people would break through that we had at the banks I worked at a dull modem, which you could bring up data that was already in the computer and had been printed out, and you could bring and you could look at it, but no one could touch the programs. And they made sure that the dull modem was far away from any PC on your desk, because there were people who were afraid that somehow the data would jump on its own from the mainframe computer onto your desk. It was absolutely ridiculous. Nobody was allowed to touch the big computers or the PCs unless you were a secured, trained programmer. It's almost humorous to think back in those days. We had a PC at home fairly early because of Nancy worked for another friend of ours who had developed a multiple listing for real estate, and she also did programming for him. But I would work in the middle of the night on the computer, and then I'd get all bollocked up and screw it all up, and I couldn't get it to work, and she'd already been sleeping, and I go up and wake her up, and she'd say, just turn the thing off and come to bed, and when you turn it on in the morning, it'll all be okay. And it was. So it was interesting, but even then, research by the books required a certain amount of skill, and just like what eventually has happened with the computers, I assembled at the first law firm that I worked at, I assembled the BNA works. The BNA, the Bureau of National Affairs, had a big paper system, just like when we were doing law research, and it was great. And you could do labor law with it. But I put together the soft books, because you went into the hard book, then you had to go into the soft books that were paperback, and then you had to go to the new sheets that came out when you did research. Now all of that is one step, and shepherdizing, which I'm sure that some of the younger lawyers on this don't even have an idea what that is. We had to double check to make sure that the case wasn't overturned in the week that you went to court. And the research was so different that one of the things that caused a pit in my stomach, and which still happens every once in a while, is you'd go into court and the other side would say, or the judge would say, well, Cliff, that's a pretty good cite and a pretty good brief you wrote. However, did you know that the Supreme Court in this jurisdiction, or in Illinois, or the US Supreme Court, they reversed that this week? And you'd be pretty embarrassed. So there was a constant fear. Now, a lot of that is still around when you deal with AI, because unfortunately, one of the glitches, or the way it works, is when artificial intelligence works by itself with one particular user, the strange thing happens is that the AI wants to give you what you're looking for. And what's happened is that they haven't solved all these glitches yet. But what happens is often the AI, the search engine stuff, will try to give you the answer that you seem to be looking for, and it'll make up a case. It'll make up some stuff that's not, it may use a real case, it may make up a site all by itself, and will put in what it thinks you want. It's tailoring to your needs, and make stuff up. Now, even in the automated research, it happened that way too, that somebody put in, so a human being would put in head notes and head notes still exist in a lot of the cases that come down, even now that it's mostly automated. And the head note may not have been correct. Or if you read the whole case, you might find some paragraph that you could use from that case to cite that wouldn't be in the head notes. I remember back in the late 70s, early 80s, one time that, well, I worked at a labor law firm and they didn't have a lot of money and they didn't pay a lot either. And they would train the newer attorneys by giving the sure losers to that person because you were the cheapest in the firm. We were a union firm, and so we had fixed retainers for most of the union, so you could bill and know that you weren't going to get paid. And that's how they taught you how to be a lawyer. And you'd go to court on mostly loser cases. And if you won, it would be a great victory. And if you lost, it was expected that you were going to lose. But it taught you how to be a lawyer. And I remember going on one time, and my opponent got really angry and says, Your Honor, Cliff is using the stuff from the actual case, not the head notes. I'm only allowed to cite the head notes. And the judge said, he listened to my argument. He says, that's very clever. I really like what you did, but you still lose. But I thought you made my day much more interesting, but you're going to still lose. That's still, still the case. And there were always a few cheaters who came in and cited a case for not what it said. And you had to double check it or make an argument on the other side. And that's still the case. And that's one of the real problems with using strictly AI and not checking it. You need to still go and look up the case and read it. One of the best things about these search engines and using artificial intelligence is it gives you a start in terms of what you're doing and gives you that hook to get into your first case. Now, AI comes in two forms, and the one I'm going to play with in a little bit is ChatGPT, or the one that's on my new computer, which is called Copilot. And we're going to play with it a little bit, and you'll see what it does. Now, I always enter not as me. I always enter as a guest. Now, if you buy the real version and you pay, anywhere from $50 to a couple $100 a month to use AI, it's got a better database that's up to date. The ChatGPT one and most of the other ones that are free but not strictly updated. So let's see. One of the things that you need to watch out for, of course, is when you put in information into ChatGPT or one of the other AI services, is that if you put in stuff about your particular client and your particular case, especially if you put in names or there's a way of backtracking and figuring out who you're representing, that may be a problem in terms of confidentiality and your obligations to your clients. So, Ted, do you want to talk a little bit?
Yeah, let me we're just following the outline that you all should have received. And so let me mention a couple of things about using AI in other legal areas. It has been part of our practice for a long time, even if we didn't know about it. For example, in Lexis, many years ago, they had put AI into a lot of the search terms that people used sort of behind the scenes. So I remember I was trying to research any cases involving a man named Leonard Wien, W-I-E-N, and it came up with things that related to Vienna, the city, which in German is W-I-E-N. So they had built that into the background, and our Lexis rep told us, yeah, we did that for a lot of things because we found that really helped the users. So that was there, and over the years it has really advanced. The databases now that are connected to several of the legal products can help you in litigation just by learning more about the judge, the jurisdiction. And so if you're preparing a case in front of a certain judge or in a certain state or even municipality, you can get the data to help you prepare a case that is more likely to win than doing it blindly. There are a number of legal research tools that are useful. Lexis is the one that I use most often, and so they have an AI tool that goes along with it that costs additional money. But the advantage to something like that over ChatGPT or one of the other general purpose AI tools is that they will tell you that their database that they've sucked into their AI tool is the Lexis database. So you won't get any hallucinations because everything that comes out of there, it's based on cases or statutes or something that's in Lexis, which over the years I think is fairly reliable as far as the legitimacy of their content. And we'll show you an example a little bit about how that looks. I think the use of AI can also be important in corporate compliance, which is something that I work on as my primary area. And it's interesting to think about the Department of Justice when they review it. Let's say there's a criminal allegation against a company, and they're trying to determine whether to prosecute, how serious a charge they should impose. They'll look at what the company has done to try to prevent the violation from happening. In every case involving a corporation, the corporation's answer is going to be, no, that wasn't us. That was just this rogue employee that ignored the instructions and violated the law. And so the question justice asks, and other enforcers, they'll say, okay, how seriously did you try to really enforce the law or enforce your internal rules? And if you say, well, we have this compliance program, we have this policy, and what you have to do is prove to the enforcer that you have a real policy and it's not just what they call a paper program. And so one way you can do that is by using electronic tools to manage the statistics of your program. How many people got trained? What were the consequences of violation of a rule? Did you use AI tools to do things like evaluate the risk of certain areas or track the potential violations, like in payments? Were there payments to, let's say, for entertainment that went to government agencies, which would be a violation? So there's a lot of things that can be done with AI, and and also sort of reflecting it. Everyone in a company who uses AI should understand what the appropriate rules are for its use, and not just turn it on for everyone's use. In litigation, AI for things like predictive coding for document discovery has been around for a while. We didn't call it AI back then, but it's very important since nowadays it's not so much some poor associate or clerk sitting and going through millions of documents. It's going through millions of electronic documents, which can be pretty deadly, but it can be expedited through the use of these tools. Let me mention a couple of ethical and privacy concerns with AI. Lawyers are getting penalized for using AI that comes up with hallucinations. So, you want to do a good legal job anyhow. So you shouldn't really just do it because you might get prosecuted, but do it because you want to do a good job. So this is something that happens. If you're in employment law, you can use AI to determine whether you're company or your client or the opposing party is using personally identifiable information improperly, which would be a violation. And
Of the rules,
what?
of the rules of the
Oh, yeah,
disciplinary
yeah.
commission.
Some of the AI providers are setting up rules to try and say, no, it's not us. And Microsoft has done a few things that I thought was interesting. They've said that we will not sell a facial recognition program that uses AI to any police department without federal regulation, because there have been so many allegations about the deficiencies of AI in that context that they're concerned, and probably rightly so. The technology there is imperfect, to say the least, with a decided failure of performance in dealing with people with dark complexions. So there's something that you need to be concerned about in terms of compliance, and we'll see what happens in that area. And so in Illinois, the Supreme Court issued guidance, and it's in your materials, effective January 1. So we're hot on it, we can do it. But basically saying, look, disclosure of AI should not be required in a pleading. Other states have taken different positions, but that's what Illinois says. They make some general statements that say that the Illinois courts will be vigilant against AI technologies that jeopardize due process, equal protection, access to justice, unsubstantiated, deliberately misleading AI-generated content that perpetuates bias, prejudices litigants, or obscures truth-finding and decision-making will not be tolerated. Okay, that's very nice, very general. It doesn't really tell you anything about what to do, but that's the policy.
Well, is there a sanction or a fine?
No,
It
No.
defined, or the judge can just impose that, right?
yeah, right. So, but this is the Supreme Court policy, and they basically say, look, you want to avoid these problems, thoroughly review anything that is produced by AI. And
So, well, we have a question in the chat about whether it's patent and trademark violations. And it is, but you'd have to bring a patent or trademark lawsuit. And it's difficult. Look, there's always been this problem between violations of ideas and violations of actual stealing somebody's product. And it's still a hard road to go down. And who owns what? And we're seeing that in the gobbling up of news, where there's aggregation of all of the local papers and everything else, which you get through just a simple search through a search engine, and then it's appropriated by AI and other parties. And what's common knowledge and what's stolen and who owns the news, it's still not altogether settled.
Right. Some of the larger publishers have started to bring lawsuits against AI tools, saying, we did not give you permission to suck into your system all of our copyrighted material. And so I think that this, the fact that it's produced by AI is not a defense if it originally was copyrighted. So I say that more litigation down the road in this area. And that's another thing to be careful about of what you get from AI is it someone else's property? So it's just something to look out for. Let me mention.
Of course, if you cited it in a brief and you properly attributed it to where you quoted it from, that's going to be acceptable. But it's just like years ago when I taught legal writing on a regular basis at then John Marshall. The story was that I had a couple students who were doing some research and writing a paper. And I came home and I had I'd read them all, and two of them seemed very similar. and I dropped them on Nancy, and she looked at the two of them, and she said, "They're not similar; they're identical." It turned out they were roommates, and I called them both in, and they were, second year law students and should have known better. So, although, I tease, they had both been stockbrokers with seats on one of the markets, which they just thought that they could get away with it. And then they admitted that one's computer broke, so the other one took the introduction page and took it out and made it as section 1, moved around the fonts and turned them in, identical papers. And they said, well, I had permission of the other guy. There's been discipline in law school for wrongly attributing or not putting quotes around something that you took all together versus rewriting it your own way. But those are only, academic discipline. Nobody can, as I know it, can copyright a brief. I see Naomi is on the call. Years ago, the company that she and my wife both worked for originally tried to say that they owned 1031 real estate exchange forms. It was just interesting to see. And then finally, Rudnick and Wolf said, no, we wrote them. So it's can you own a concept like 1031 exchanges? I mean, that's where it all kind of breaks down. But you're not supposed to put in your brief, and you're not supposed to do it. And there's court cases where you either have to disclose that you used AI or you've got to change it. There's software now developed that is used in the law schools, because I know about that, where they run a paper through this machine program that says whether the machine thinks it was created by AI or not. Or what happens is that the professor takes the same issues that he or she put for the problem and runs it through AI and sees who comes out the closest to it. But then, of course, the student says, it was just serendipity. I just did it all on my own. It just came out very similar to the one at AI. Or they admit, they use it.
There have been tools around, and I know at Loyola, every paper that's turned in is run through a program that's designed to detect plagiarism, short of AI. So if someone just lifted something in whole from some other source, it picks it up. I usually warn the students about this the first day, and things have not been a problem. The only time I've gotten a hit on this program is when some student has put in a long quote of a statute or a regulation, and then the machine will come back with, oh, this was copied from somewhere, and sure, that's okay. So there are tools there. I'm not sure what the ability is going to be to detect something done by AI, but once again, I'll rely on warning the students, please don't expect that you can write your final paper with ChatGPT or something else. Let me mention something a little bit. There were about 300 statutes that went into effect in Illinois on January 1. One of them, and I just did a real quick scan of the 5-word description of the statute. One of them says it's illegal to create a digital replica of individuals via generative AI without the consent of the recorded individual. So you can't use AI to generate ads of people unless they're giving you permission to do that. So I think that's something, wherever there's an application of AI in some sort of business situation for your client, you need to make sure that it's proper, they have all the needed consents. The FTC has been looking at, not at AI in general, but in specific areas like the use of chatbots that sort of, in some cases, pretend to be a person. And so they have some guidance of what will be a violation of the FTC Act no, you can't misrepresent something and then blame it on the chatbot. No, you're liable. If something's an ad, you have to make sure people know that. And companies, however, are investing more money in making their bots more realistic. And there are a couple I mentioned in the outline. One is called Claude, which is very popular in Silicon Valley, which does not pretend to be a person, but has responses that are more informed than others. There are a couple of chatbots. One is called Character AI and one is called Replica that are they try as hard as they can to fool you into thinking you're a person. I would advise against that now because the consequences, if it becomes known, are serious. And Microsoft Copilot, which is now being delivered for free with the latest version of Windows, they say, look, if you're a lawyer, you can do lots of things with AI, and it's particularly our AI, and you should try it just to save yourself some time. And they gave 10 examples that I copied on the outline, which I think is worth a try.
Let's try that. Let's see if we can do that. Let's see. I lost it. Let's see.
All right. So while Cliff was trying to do that, let me mention what else is in your outline. I put in a question to both Lexis AI and ChatGPT. And the question was, what kinds of integrity and compliance issues are for-profit higher education institutes concerned about? So here was, if it's a school that's specifically designed to make a profit as opposed to a nonprofit educational institution, is there anything special that they should worry about? And I printed out what came from the Lexis AI assistant, which shows you the format they use, how they approached it, and then the thing that's nice about Lexis AI is that it gives it citations. Here's the basis for what we said. And then I actually had a colleague put it to, well, let's put this same question into ChatGPT. And then you'll see what I think is a little better answer because it's covers more issues than just what's in the statutes, which says to me that, sort of think that you should do both. When you're looking at a question, run it through a legal specific AI tool and run it through a general one. Okay, Cliff, are you ready to go?
Yeah, can you all see Ted, can you see it?
Yep.
The Copilot?
Yeah.
All right, so what should we ask it?
Well, you want to ask one from the outline?
Yeah.
Okay, does divorce change my life insurance beneficiary in Illinois?
All right. Is it true?
Well, not being a divorce lawyer, I have no idea.
Do we have anybody on the call who's an expert in this? You can unmute, I guess, or Aviva, can they unmute? I think that this is true.
Well, certainly the answer looks good.
Yeah, but we don't know whether it's true or not.
Yeah, so the reason that something like Lexis AI, and I assume that what Westlaw has a similar version and Bloomberg has a similar version, is you could able to feed it in there and see if it's true. So let me see if I can do a real quick one on Lexis AI as a request from the audience. Let's see what they say. So give me a second to do this.
Well, let's ask ChatGPT at the same time and see what it does.
Okay.
Let's see.
And you both should be able to share, but I don't think you can do it at the same time.
Okay.
Ted, you want to share your screen and show people?
Oh, let's see. I'll do it mine. I'll do mine. And let's see. That was, what was the question? It was, does, let's see, how did you write it, Ted?
Does divorce change my life insurance beneficiary in Illinois?
And again, I think I see a few people on here who I thought are family law practitioners.
Maybe they're afraid. You know, I used to have really great typing skill, but since it corrects me all the time, my 7th grade summer school typing has always kept me in pretty good. Now look at, they don't agree. Now,
Ooh.
part of the reason they don't agree is maybe the law just recently changed, but this is a more conservative way, but usually it has something on it that says, go talk to your lawyer. But you see how it's different. Let me give you something that's even funnier. Let's see if we do this other one. Let's do another one. It gives you so many tries. I'm going to ask it, would you like to go on a date with me?
We can't see your screen.
Oh,
Can you share your screen now?
yeah, hold on a minute. Stop share. Let's share. All right, so what I asked it is if it would go on a date with me. Can you see it?
It's a little blurry. Why don't you read it first?
All right, I appreciate the sentiment, but I don't have personal experiences or emotions in the way humans do. However, I'm here to chat and provide support or advice on any topic you like. How can I assist you today? So it's funny, the last time I put that question in, it came back and it said the same first sentence, but it said, however, I can play games with you if you'd like. But some people actually think, you know, still that there's a person back there doing this stuff, but there's not. And you'll see that these two search engines gave different answers to the law question. I'll put that one up again. Could you see that one before? No, I don't think so.
All right, so I'm going to tell you what Lexis said if I could get this onto the screen.
All right.
All right.
Let me stop share. and see if you can do a share screen, Ted.
Mhm.
It's on, it's on the bottom of the green box. Should go with your screen. Is it letting you share? Double click. Yeah, it says you're able to do it. There we go.
It's not what I want to do. All right, so,
No, you wanted to do the other part of your,
all right, so let me see if I can do it this way.
see, we're not quite Luddites. Aviva, how many minutes do we have left?
We have 14 minutes left.
Right. We can open up for some other questions too.
Okay, so I'm trying to paste something into a document that, all right, so. All right, so here's what it says. In Illinois, divorce can change the life insurance beneficiary under certain conditions. So there's a quote from the statute, and then another quote from a statute that talks about divorce, and then a discussion of the case law that supports the fact the statutes, and then it gives a little historical context. And says that the cases say, no, a divorce decree does not automatically affect the rights of a divorced spouse as a beneficiary. Interesting. And then there's the quotes sent below. So there would be advantages. I think, my guidance would be, I'm going to stop share here just to go back to the screen. Something like this is a great way to start, but check your answers. Okay, does anyone have a question?
Well, let me just mention a couple
you-
things and then we'll
okay,
open
go
up the
ahead.
questions.
I want to mention
So,
that, Cliff, wait 1 minute. Curtis did answer the question about when we asked what is the law on this. So I don't know if people saw it in the chat. He said normally a divorce will revoke the insurance beneficiary. However, if there are rights created by contract, the answer could be different. So I guess the question would be, like, perhaps that's why we have two different responses in the AI that you
yeah.
you
Well,
found.
and I think
How does-
the
what
other
does-
thing of those of us
do
who
people
are,
need to do when that happens?
so, the best policy, of course, is the one that we all learned from either experience or from somebody who taught us, is call the insurance company. I know that in trust and estates right now, we're going through quite a trauma with Illinois and the new statutes involving durable powers of attorney for healthcare and property with an outside advisor and what can be revoked and can't be revoked, and having a real hassle. And there's exceptions that banks can and can't reject a durable power of attorney for property, and it's complicated. But the best thing to do is, just like with the life insurance, is call the darn life insurance company and tell them what's going on and make sure that they are accepting and updating this thing rather than having to litigate it later on. I, as a trust officer for all those years, not having so much to do with AI as having to do with interfacing between banks and trust departments and insurance companies, we'd often get somebody from a bank that had moved into Illinois or a trust department that had moved into Illinois that's based in North Carolina or California or New York or New Jersey. And they'd say, well, in New Jersey, we do it this way. And I'd say, you're not in New Jersey, you're in Illinois. And they'd say, well, that's what we're going to do. That's our policy. And finally, I'd figure out the best way to do it was to call the local bank that they had here in Illinois and ask them to talk to their trust counsel for Illinois. And it usually turned out, as I'm old and have been around a long time, that I knew them. And ironically, a lot of times I trained them. And so,
All right, Cliff, what do you want to do? You want to ask if there's a question from the audience? You want to try
Yeah.
one of the others on our list?
yeah, I think that's right. Let's see that. Is there anybody else who has any
Or have you
questions? We can
frozen?
unmute for a few minutes. Or Aviva will unmute you all.
I said it so people can unmute themselves.
Anybody want to tell a war story for their AI experience? I was going to tell you about the Colorado case for a minute. So in 2023, a Colorado judge suspended a lawyer for using ChatGPT to draft a legal document because he didn't read what he had gotten from AI. He just used it and didn't double check it. And judge ordered his name is Zachariah Craybill, to a 1 year and 1 day suspension after Craybill allegedly cited case law that he found through artificial intelligence platform GPT, and it turned out that it wasn't a correct quote. And so you can be disciplined for this. And he was not so much disciplined for using chatbot GPT, but for not double checking it and not for admitting he'd used it. And this is going to evolve more and more. The question is whether these search engines are responsible and the AI is responsible and can be sued. And so far, it doesn't. But this whole area is so alive. You can see what's happening right now in terms of truth and fact-finding and fact-checking by these engines that all utilize some degree of AI, saying we're just a conduit. You can take the information and use it. We are not a publisher. We are not liable, and it's only going to continue until finally the Supreme Court decides who's liable for what. There have been cases over the years that Reddit and some of the other things have done where chatbots created responses. You can see it on Yelp all the time that somebody didn't like a restaurant and they created 400 zero or minus reviews and crushed the restaurant, or they made up all these wonderful reviews, and when they got sued, it turned out you couldn't prove who had written them. But a lot of times, if they found out that the search engine had generated them, there is liability for the search engine owner. But it's still going to be an area of the law that's got to be sorted out. And if it's anything like what's happened in the past, the worst example, of course, being how long it took for durable powers of attorney for healthcare to develop in Illinois and in the other states. The history was that heart-lung machines really changed of how somebody was considered to be alive or not, or functioning or not. And it took years of whether it was the heart or the brain that died, which made somebody dead. And it took Illinois and most of the other states 10 years to sort that thing out. So if that's the case, it's going to take at least 10 years for chatbots and everything else to be straightened out by the law, if ever. So
I think there are two separate issues that there are a lot of issues, but two big buckets that I think that lawyers need to be concerned about. Number one, how do you use AI in rendering advice? And number two is, how do you counsel your clients on their use of AI when it exposes them to unusual risk or when it might be helpful to their business? And I think that suggests that we all must have a little knowledge about AI, the same way that many years ago the states said, you as a practicing lawyer need to use these tools of legal research in order to do a good job. So I think this will become part of our practice more so than it is now. And it's just going to be incumbent upon everyone to become familiar with this subject, because let's suppose that a client uses AI for something that turns out to be bad. And you had reviewed their business and never mentioned this to them. Are they going to come back to you for malpractice? It's a possibility. So we have to be alert to these things. And if nothing else, give a disclaimer to the client saying, we're not passing upon your use of AI, but this deserves more investigation.
The other thing that's going to affect is fees, because, you know, I go back a long time in real estate. And when I first started to practice in the late mid-70s, title insurance was there, but it wasn't universal, especially outside of the big cities. And there were still abstracts, and you'd go get this grantor grantee book that would go back to the 1800s, and you'd have to do a synopsis of that book, and you could charge a heck of a lot of money doing research, or you owned the last search and you charged the new lawyer, or you did it yourself and you owned that proprietary abstract search. And then title insurance came in, and that whole business just went away. So it used to be that when you wrote a trust document for somebody, it was a labor. It was a labor to type it. And also you made these codicils or the fifth restatement, and you changed this clause and that clause, and you had to lay out the other four of them on the table and figure out which paragraphs you changed. And then when the software came in, you would do it when you do a restatement of a 45-page trust. You'd press a button and you'd say, I hereby revoke all prior ones and I replace it with this one, and you do the new one. And the software has really helped both to develop that document and to print it out, so that what used to be a real physical labor and a thought labor to write that document, now you had this prototype self-declaration of trust. You pressed a button, you did an interview through with AI, and you produced the whole darn thing in less than 20 minutes. And you use the one that you wrote for the person before as your prototype. And you can't rationalize charging somebody several $1,000s. They could sue you and say you didn't do anything to earn that money.
Let me take a slight differing opinion on that. So if nothing else, it'll cause us to rethink the hourly basis for billing, because what we're talking about is what is the value of what we're giving to the clients. And I think when you use a tool like that, that significantly shortens what has been the traditional time to do something, I think you shouldn't really, you shouldn't pretend that I spent 60 hours in this when you didn't, but you can bill based on the delivered product, charge for redoing your trust, $10,000, whatever it is. And I know that the firm I use to do my own family documents doesn't give me an itemized bill by the hour, but gives me okay, this is what it's going to cost.
Package.
And so I think that's where we're going to have to go on a lot of these things. There will be things where an hourly rate is still the only thing you could do, or a contingent fee or a partial contingent. I mean, other things, but this is something to think about. I'm not sure that jumping from a 60-hour project to a 2-hour project, because that's what it took you, reflects the value of the work the lawyers did. So think about value delivery in this.
So I think we're done, right, Aviva?
Yeah, we're almost at time, but I have one quick question, because you're talking about liability. Do attorneys' liability policies cover them if a client sues them for having used AI and the citation was wrong? And is there any coverage for them?
Well, it depends on whether there was negligent or intentional. I don't know of any of the insurance cases that affect that so far. The committees I'm on, and I'm insured by ISBA Mutual, and they run a pretty vigorous, robust lawyer training program. And I have not found anything yet that gets it either protects or comes out any different, whether it's negligent or you have an obligation to do it yet.
Right, what
I
I
don't know if
think.
Ted has seen
But
anything.
the key question is not whether you used AI, but whether you committed malpractice. And if you cited cases incorrectly, however you did it, I don't think it matters.
Yeah.
That was the violation, not the fact that you used AI. That will be.
That you were right, you either did it intentionally or recklessly
Yeah.
disregarded your obligations as an
Right. And
attorney.
it could have been, not checking work done by a clerk, so if the result was wrong and that's the violation.
But
things
not
can-
just using AI.
Yeah, not AI, but so all of that says we still should use it and we still should get very comfortable with it in all its incarnations. Getting something like Lexis AI or the Westlaw or Bloomberg equivalence is not inexpensive. And so you have to think about that, but I think everyone should at least get a free demo of what the AI tools can do so that you're familiar with it. I found it to be very useful in my practice. And we've only had it for a few months, but everyone who's jumped in it in the appropriate case has said, this is really very helpful. It's not.
Are you paying for one, Ted?
Oh,
Or
yeah.
using a free one? You're
Well,
paying, right?
my firm is paying for it. I get free ones through Loyola, but my firm is paying for it, and I keep those two things separate. But it's still worth, at a minimum, become familiar with it. Consider whether it will help your practice, and it may not be in terms of speeding things up. Microsoft, as it shows in the outline, they insist that Copilot, which is free, can speed up your practice. So it's at very least give that a try.
Just like when Google put in Google Scholar to try to drive everybody else out of business.
Okay, well,
Yeah.
thank you very much. Very informative, very enlightening discussion. I know that for some people, they might already be using this. If they're not, they might have questions. And can people follow up and reach out to one of you if
Absolutely.
Yeah, same here. If you have a question, let me know.
And Aviva, did you hype the Martin Luther King Day event?
I will do that shortly, but I just want to stop the recording so we can all talk.